Well, the Supreme Court will soon decide if challenges to EPA's small refinery exemption can be heard somewhere other than the D.C. Circuit. Troy Bredenkamp with the Renewable Fuels Association joins us now with industry reaction. Troy, always a pleasure. Thanks for being here. What we know, this comes following the EPA's denial of SRE applications under the Renewable Fuel Standard. So tell us what's going on here. Where do we currently stand?
Yeah, so when you have a national standard like the Renewable Fuel Standard, we've had it on the books for almost 20 years. It is a national standard, so those kinds of programs within the EPA and other agencies are best handled in a circuit that handles national type issues. And that's the way it's been for years. When there is a challenge to the Renewable Fuel Standard, typically those challenges go to the District of Columbia Circuit because it is that overarching national type of circuit. What we had happen here, Suzanne, is we had a refinery take one of their small refinery exemption cases to a smaller circuit, the Fifth Circuit, which handles, I believe, Texas, Louisiana, and Mississippi, one that would be somewhat favorable, I think, to a refinery. And they made a decision in the Fifth Circuit. And what we have challenged and what the EPA has challenged and the Supreme Court has elected to take this case on is to say that wasn't the proper venue. The proper venue for a national type program like the Renewable Fuel Standard is the DC Circuit. And this is exactly why the Supreme Court exists, is to decide on cases like this where you have one circuit doing one thing and another circuit doing another. This is why the Supreme Court needs to make this decision once and for all to have clarity on who does have jurisdiction here. We believe it is the DC Circuit.
So the drive then to have a court decide these cases outside of DC, I mean, this would really have a big impact on the situation.
It certainly would, Suzanne. So, for example, if the Fifth Circuit was able to make their own decisions on how small refineries within those three states should be handled, you could have the same with the 10th Circuit. You could have the same with any circuit could be going out and doing their own decision making when it comes to this national program. That is why you really need one standard and one circuit, which in our mind should be the District of Columbia Circuit, making the decisions when you have these cases that are national in scope. And so that's what we hope the Supreme Court decides. If we were to have different circuits doing their own thing and there was small refinery exemptions being allowed across the board, that would not be a good thing, obviously, for the biofuel industry, and certainly not a good thing for agriculture when we're facing, decreasing commodity prices. This would certainly not help boosting demand for biofuel and using those commodities as a feedstock.
Troy, before I let you go, real quick, what kind of timeline are we looking at before this case is decided? And I guess you're thinking that they are going to go to hold this in the D.C. Circuit.
We would hope so. We would hope that the Supreme Court would decide that the D.C. Circuit is the circuit of jurisdiction on this case. Supreme Court typically hears cases in the fall and the spring, and those decisions typically come out early summer to late summer. So it's not a quick process, but it is hopefully a process that will once and for all put this issue of venue to bed.
All right, Troy, thank you so much for joining us this morning. Troy Bredenkamp with the Renewable Fuels Association.